a 2016 case of a guy who wanted to make a machine gun. ATF said, yeah, go ahead, no wait, stop. And this just seems to be a habit with this group.
Yeah, he got ATF'd. So
nice. Always think forfeiture. They came and took it, didn't they?
That's right. It's you give it and you take it back. That's the ATF. So we had a gentleman by the name of Jay Hollis who filed a Form 1. So in order to, for those of you who don't know, Form 1 is a federal form, thanks to the NFA and the Gun Control Act, that you can file if you're trying to build an NFA item, add it to the registry, and put it under your name or the name of the trust or whatever corporate entity you have.
So this is your building one, like from scratch or creating one?
Yeah, he's constructing one. And today you can still Form 1 short barrel rifles, short barrel shotguns, you can Form 1 suppressors and other things. But thanks to the Hughes Amendment back in 1986, you're not allowed to Form 1 any machine gun. So what that act did is it said, look, you cannot, so this is part of the Firearm Owners Protection Act, broadly speaking, this kind of raft of legislation out there. They said, look, no new machine guns can be owned by civilians. Whatever's out there is grandfathered in. So you get these terms like pre-86 transferable, all this other kind of stuff. But as of, I think the date was May 19th, 1986, no more Form 1s for any machine guns that can be legally transferred to civilians.
Yeah, the machine gun had to be built before 1986 in order to meet the criteria set forth.
Yes. So when Jay Hollis decides, well, I'm just going to Form 1 a machine gun, let's see what happens, and then he got the approval back from ATF, hey, I found a neat little loop in the matrix here. And then, of course, quickly thereafter, the ATF contacted him and said, no, you can't do this.
That guy got fired.
Yeah. And if you did, you have to destroy it. Mm-hmm. And Hollis is like, watch me, and sued.
Yep.
And away we went. And the interesting thing about this particular case, so we got this case called Hollis v. Lynch, and is that there's a lot of kind of fault lines, a lot of ambiguity that's out there that actually gets kind of, I'm not going to say cleared up forever, but it gets addressed and treated by the court as part of this case. So there's another case called the Miller decision, which comes back from the late 1930s. That other than the Miller decision, we really have no Second Amendment case law. I mean, we do. There's Thompson Center and there's other cases, but Miller is probably the biggest Second Amendment case that we have out of the 20th century. And Miller was basically this gangster who sawed off a shotgun, got caught transporting it, and was charged with a felony for being in possession of a sawed-off shotgun that was not registered, contrary to the National Firearms Act in 1934. And Miller, who actually died prior to his case making it to the U.S. Supreme Court and was actually unrepresented as part of arguments there. But nonetheless, the court went ahead with hearing the case. And interestingly enough, what the court said is they said, look, the reason why we're going to uphold the NFA and we're going to uphold the conviction against Mr. Miller is the fact, well, again, none of that exactly mattered because he was dead.
Yeah.
But just the same, is because, you know what, sawed-off shotguns have no military use. There's no military purpose to it. And that's the whole idea behind the Second Amendment.
Quick pause here to remind you that we have a super secret giveaway going on right now. It's absolutely free. Just click the link in the description down below to find out what you could win. Now back to the video.
And of course, that's not exactly what we've been hearing over the last better part of 30 years now, right?
Yeah.
Where anti-gunners say, well, that AR-15 has no sporting purpose. It's like, well, yeah, arguably your uncle's duck hunting shotgun actually is less protected under the Second Amendment than your AR-15 is, by the way. But we'll get into that in a moment. So the lawsuit triggers all sorts of interesting discussions of what type of firearms are actually covered. Are they the types of firearms that are going to really be made and built heavily for military purpose? What happens for sporting purpose? Just all this kind of stuff. What's really kind of the purpose of the Second Amendment? Because Hollis is making all these arguments in court. There's all sorts of arguments he made. Some of them are very technical and dry, but there's a couple more interesting ones I kind of want to share with you. And one of them is, well, look, we have to be able to fight against tyranny. and harder to do that with my uncle's double barrel 12 gauge, duck gun or skeet gun, or whatever the case may be. I'm better off with an M16, i.e. what I was trying to get my Form 1 approved for, right? And I'm going to piss off some people on the internet, but just keep in mind, it's not me saying this, all right? I'm just the messenger here, all right? I truly am. The court says, no, this is a misreading of Miller. There's basically a two-pronged test, all right? The gist to it is, when we're talking about firearms that are in connection with military purpose, that's fine, but they also have to come from the militia. They have to come from the people, because the concept behind the militia was that the militia is bringing the weapons from their homes. It's coming from among the people. Now, yes, I can hear the keyboards clacking away. There's approximately 175, 180,000 transferable machine guns registered under the National Firearms Act right now. That number diminishes with each successive year. Maybe the topic of another video as to why, because I can go off on that. But neither here or there right now, all right? Of course, they would be much more in common use in the militia if we were allowed to buy them and add more and manufacture more and so forth, right? And ultimately, that wasn't exactly an argument that the court highlighted here for us, all right? But at the end of the day, the court says, look, it's not really a weapon that's, as a result, kind of part of the militia. It's not a weapon that's, they didn't exactly hone in on the phrase common use as much, but that's kind of their analysis that they got into on this to say, look, M16s and machine guns also are, and they got into dangerous and unusual language as well. They're a dangerous and unusual weapon. There's a couple cases that they cited to on that to say, look, these are dangerous and unusual because the Second Amendment, according to DC versus Heller, does not apply to weapons that are dangerous and unusual. That's also followed up in the Brune decision. So if a weapon's dangerous and unusual, that's a no-go.
And the definition of unusual would be something that not a lot of people have or isn't very common. So AR-15 should not fall under that definition.
Oh, AR-15s, as you know, is America's #1 most purchased firearm, period.
Yes.
Okay. Courts have spoken to what constitutes being an unusual, because there's, so that's the language that's out there, and that language actually comes from us from the 17th century England and all this other kind of stuff. And it's part of what we have here is that, well, you can have a weapon as long as it's not dangerous or unusual. And think about that in a 17th or 16th century context. What does that exactly mean? Well, transport that now to where we are today. The way the courts have interpreted what that broadly means, first off, keep in mind, all weapons need to be bearable to be covered under the Second Amendment. Mm-hmm. So bearable, we're presumably not talking about maybe tanks, aircraft carriers, things like that. That's going to be less bearable. We're talking about things that can be carried, moved, that kind of stuff. Okay. Again, only the messenger here, guys. Okay. So when we talk about what's unusual, so we have the Catano case, which was a case that overturned a New England state, Massachusetts, that was trying to basically do away with stun guns. And interestingly enough, the presumably somewhat anti-Second Amendment court in Massachusetts, the Massachusetts Supreme Court said, you know what, we're upholding the law that's banning stun guns, tasers, that kind of stuff, electronic devices, because you know what, it doesn't really have much connection to military service, and the Second Amendment is fundamentally about military weapons. Which may come as news to you, by the way, because of course, gun grabbers are always saying, well, AR-15s are a weapon of war, which of course they aren't, but just the same, they're a weapon of war and they're so incredibly dangerous and all this other kind of stuff on the one hand, so therefore we have to ban them. And then in court, they're taking away tasers because they're saying, well, there's no military application to these.
So it's not covered.
It's not covered, exactly. Of course, and if we go back to those tyranny arguments, the same argument is, the AR-15, which they're going to say is so incredibly dangerous and just no one needs that at all, and it's a weapon of war. What are you going to do against the U.S. military? What are you going to do to fight against tyranny with your AR-15, right? Yeah. It's trying to have it both ways all at the same time. But ultimately, Hollis winds up losing, and that's kind of the gist of the case. But the biggest things that came out of it, like I said, come from the fact of, look, it's not like just because a weapon's used in the military, that means everybody gets it. They basically continued to uphold the NFA Act in the wake of DC versus Heller. Now, it is a pre-Brune decision, so we don't have the Brune framework of, does this fall inside the historical framework of laws and all this other kind of stuff. But I will point to the fact that the U.S. Supreme Court while it has not explicitly talked about NFA as being go or no go, if I had to put my money on it, and again, this is not saying what I would like to necessarily happen, this is simply a legal prediction that the NFA will absolutely be upheld if there's some sort of challenge that goes all the way to the Supreme Court.
Yeah, and I would imagine that people are looking at what cases they can bring to add question or add clarity to, is the NFA constitutional? Is it,
Right.
and you're saying right now that you think it will be upheld. I'm kind of thankful this Hollis guy had apparently unlimited funds to fight this. He must have really wanted to build a fully auto M16 in order to fight this all the way through to the Supreme Court.
I said, and I'll add to this now, that I do think the NFA will be broadly upheld, but that doesn't mean that every article in the NFA will be upheld. So, for instance, claiming that a machine gun is a dangerous and unusual weapon and there's 175,000, give or take, in circulation, it seems like the courts, if I had to bet, they're going to uphold that. Okay. But on the other hand, where does that leave us with suppressors, where there's a lot more SBRs? I mean, particularly if the pistol brace rule winds up being upheld, right? And even if it isn't upheld, even if the pistol brace ruling gets struck down and everything can remain as unregulated pistols, right? The ATF just finished saying these are all SBRs.
Yeah.
Which means that they're now explicitly, not implicitly, explicitly saying there are millions, potentially tens of millions of these SBRs out there. Again, you've opened the floodgates as far as taking down the NFA, at least piecemeal, hopefully on a series of challenges to SBR, SBS, suppressors. I just don't think given the body of law that's out there, I don't think that they're going to overturn the machine gun part. That might be what's left down the road, but we'll see. Time will tell.
Yeah, absolutely. As I've said so many times now, the cases that have come before the Supreme Court and gone in favor of gun owners are not the end. They're just the beginning, and this is just another great point. So thank you again, Tom. Always great insight. Truly appreciate it.
Thanks, Kevin.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.